Chicago divorce attorney. If you are facing divorce in Chicago, the uncertainty around property, parenting, and support can feel overwhelming. Illinois is a no-fault divorce state under the Illinois Marriage and Dissolution of Marriage Act, which means the only ground for divorce is irreconcilable differences. You do not need to prove adultery, abandonment, or other wrongdoing to move forward with a divorce. To obtain a judgment of dissolution based on irreconcilable differences, spouses must have lived separate and apart for a continuous period of at least 6 months before the court enters the judgment. Living separate and apart does not require separate residences, and couples may remain in the same home while maintaining separate lives. Illinois courts also require that at least one spouse be an Illinois resident for 90 days immediately before filing or at the time the court enters the judgment. Many people want to know how long divorce takes in Cook County, and the answer depends on whether the case is uncontested or contested. When spouses agree on all issues, an uncontested divorce typically takes about 60 to 90 days from filing to final judgment, assuming paperwork is properly prepared and the court has availability. When spouses dispute issues like parenting, property division, or maintenance, a contested case can take 12 to 24 months or longer due to discovery, hearings, and trial scheduling. Illinois divides marital property and debts using equitable distribution under 750 ILCS 5/500 which focuses on a fair result rather than an automatic 50-50 split. Marital property generally includes assets and debts acquired during the marriage, even if only one spouse's name appears on the account or title. Non-marital property may include assets owned before the marriage, gifts or inheritances, and property designated as non-marital in a valid agreement, but commingling can change that analysis. Courts consider factors such as the length of the marriage, each spouse's economic circumstances, contributions to the marriage, age and health, employability, tax consequences, and any dissipation of assets. In cases involving children, Illinois uses the term parental responsibilities rather than custody, and the court allocates decision-making and parenting time based on the child's best interests under 750 ILCS 5/600 and 750 ILCS 5/600 Decision-making can be joint or allocated to one parent, and it may be divided by categories such as education, healthcare, religion, and extracurricular activities. Parenting time schedules are evaluated with attention to the child's safety, stability, and relationships, and the court considers factors like each parent's past involvement, the child's adjustment to home and school, and any history of violence or threats. Child support in Illinois is calculated using an income shares model that looks at both parents' net incomes, the number of children, and the parenting time schedule. Spousal maintenance, formerly called alimony, is governed by 750 ILCS 5/500, and courts decide whether maintenance is appropriate, as well as the amount and duration. For many cases with combined gross income under $500,000 and no prior obligations, the guideline formula uses 33.3% of the payer's net income minus 25% of the payee's net income, with a cap so the recipient's total income does not exceed 40% of the combined net income. Maintenance can also end automatically if the recipient remarries, either party dies, or the recipient cohabits on a continuing conjugal basis. If you want a clearer path through these rules, a divorce lawyer can explain how Cook County courts typically handle the issues that matter most in your situation. Molly Caesar and Michael Ian Bender are attorneys and founders of Caesar & Bender, LLP, and the law firm handles matters ranging from amicable settlements to high-conflict litigation involving substantial assets and contested parenting disputes. Michael Ian Bender previously served as a Circuit Court of Cook County domestic relations judge and presided over more than 40,000 family law proceedings. Mediation may be an option when both spouses are willing to communicate, disclose financial information, and work toward compromise, but litigation may be necessary when negotiation fails or someone acts in bad faith. After divorce, Illinois allows modifications of child support when there is a substantial change in circumstances under 750 ILCS 5510, and maintenance modification depends on the terms of the original order. If you are deciding what to do next, speaking with a divorce lawyer early can help you understand timelines, required filings, and the trade-offs of settlement versus litigation. For help with divorce matters, contact Caesar & Bender, LLP at 150 North Michigan Avenue No. 2130, Chicago, Illinois, 60601, United States, or call 312-236-1500.